Citizens of the gallery, one of the most dangerous phrases heard in court is, "I don't need a lawyer." Sometimes it's confidence. Sometimes it's frustration. Sometimes it's desperation. But while the Constitution protects a person's right to represent themselves, it does not protect them from the consequences of doing so. Today we examine one of the most misunderstood constitutional rights in American criminal law, the Faretta right. I am Polamopicus, and this is Polamopicus Legal Concepts Explained for Non-Lawyers, by a non-lawyer for educational commentary, and is not legal advice.
One of the most dramatic moments in any courtroom happens before a single witness is sworn. The defendant stands, looks at the judge, and says, "Your Honor, I wish to represent myself." Television often treats that moment like an act of courage. Sometimes the internet treats it as proof that lawyers are unnecessary. Others believe it is a guaranteed disaster. The truth is more interesting. The Constitution protects a criminal defendant's right to represent himself. But that protection is not based on confidence. It is not based on legal ability. It is not even based on whether the judge thinks it is a good idea. Instead, it is based upon one of the oldest constitutional principles in American law. Personal liberty includes the freedom to make important decisions, even bad ones. The Faretta right is one of the most misunderstood constitutional rights in criminal law. The Sixth Amendment guarantees numerous protections for criminal defendants. Among them is the right to the assistance of counsel. Most people stop there. They assume that means everyone charged with a crime must have a lawyer. But the Supreme Court recognized something deeper. If the Constitution gives you the right to choose counsel, then it also protects your ability to reject counsel. That became the foundation of Faretta v. California. Anthony Faretta was charged with felony theft in California. He wanted to conduct his own defense. The trial judge refused. The judge believed Faretta lacked sufficient legal knowledge. That sounds reasonable. Most people would probably agree. After all, criminal law is extraordinarily complicated. But when the case reached the United States Supreme Court, the court saw a different issue. The question was not whether Faretta would perform well. The question was, who gets to decide? The government or the defendant? In 1975, the Supreme Court answered, "A competent defendant has a constitutional right to represent himself if he knowingly and voluntarily waives the right to counsel." That decision permanently changed American criminal procedure. One of the biggest misunderstandings is believing Faretta guarantees a fair outcome. It does not. Faretta protects choice. The court essentially said, the Constitution protects personal autonomy. If a competent defendant understands the risks, the government generally cannot force an attorney upon him simply because everyone believes that would produce a better defense. Notice how different that is from saying self-representation is wise. Those are two completely different ideas. Before allowing self-representation, judges usually conduct what lawyers call a Faretta hearing. This is one of the most important conversations in the entire case. The judge will often ask questions such as, "Do you understand the charges? Do you understand the possible penalties? Do you understand that attorneys spend years studying criminal law? Do you understand that you will be expected to follow the same rules of evidence and procedure as licensed lawyers? Do you understand that the court cannot help you present your case?" The purpose is not to discourage the defendant. It is to ensure the waiver of counsel is knowing, intelligent, voluntary. Those three words repeatedly throughout constitutional law. Many people assume, if I don't know enough law, the judge can't let me represent myself. That is not the constitutional standard. The Supreme Court made clear that legal knowledge is not the test. Otherwise, the government could simply deny every Faretta request by saying, "You aren't good enough." Instead, the court looks at whether the defendant understands the decision being made. A person may know very little law and yet still possess the constitutional capacity to decide who will present the defense. This surprises many people. Someone chooses self-representation, then quickly realizes criminal procedure is difficult. Naturally, they begin asking the judge questions. What objection should I make? How do I admit this evidence? What rule applies? The judge cannot answer those questions because judges must remain impartial. Helping one side would destroy neutrality. The courtroom is not transformed into a legal classroom simply because someone elected self-representation. The rules remain exactly the same. Sometimes judges appoint standby counsel. This attorney remains available if needed. Standby counsel may answer procedural questions, help maintain orderly proceedings, or assume representation if circumstances require. But there is an important distinction. The defendant, not standby counsel, remains responsible for presenting the defense. The lawyer is available. The lawyer is not in charge. Faretta does not mean every request must be granted. Courts may deny or terminate self-representation under certain circumstances. For example, if the request is made only to delay trial, if the defendant becomes seriously disruptive, or if the court determines constitutional competency requirements are not satisfied, the courtroom must still function. Constitutional rights exist within constitutional procedures. The original case is Faretta v. California, decided in 1975, but later decisions refined the doctrine. In McCaskill v. Wiggins, the Supreme Court explained the proper role of standby counsel. Standby counsel may assist, but the defendant must remain in actual control of the defense. Later, in Indiana v. Edwards, the court recognized that some defendants may be competent to stand trial while lacking sufficient mental capacity to conduct a trial themselves. That decision acknowledged that competency is not always an all-or-nothing question. Together, these cases show that Faretta is neither absolute nor unlimited. Some believe, my constitutional rights mean I don't have to follow courtroom rules. False. The rules of evidence still apply. Procedural deadlines still apply. Court orders still apply. Some believe, the judge has to help me. No, the judge remains neutral. Some believe, I'll get special treatment because I'm not a lawyer. Generally, no. Courts may explain procedures, but they cannot become your advocate. Some believe, representing myself gives me an advantage. Usually the opposite. Lawyers spend years learning how litigation actually works. There is an old saying often attributed to the legal profession. A person who represents himself has a fool for a client. Whether one agrees with the wording or not, the point is understandable. Trials involve constitutional law, criminal procedure, evidence, jury selection, witness examination, motions, preservation of appellate issues, and strategic decisions that can affect the entire case. Knowing the facts is not the same as knowing how to present them within the rules of court, and that is a huge difference that matters. Faretta is ultimately not about lawyers. It is about liberty. The Constitution recognizes that government should not force legal representation upon a competent defendant who knowingly rejects it. Freedom includes the ability to make decisions others consider unwise. That principle appears throughout constitutional law. Personal autonomy often carries personal responsibility. The right to counsel is one of the greatest protections in American criminal justice. But the right to counsel also includes, under appropriate circumstances, the right to decline counsel. Faretta did not create a shortcut. It did not promise success. It did not declare that representing yourself is a good strategy. It protected something more fundamental, which is the freedom to choose who speaks for you in court. Sometimes that choice is an experienced attorney. Sometimes it is yourself. The Constitution protects the choice. It does not protect you from the consequences of making it.
If you like this content, then kindly hit like, subscribe, and share. Caesar commands it.